Be good to get started.
Okay. All right. Good afternoon, everyone, and welcome to a meeting of the Public Safety Subcommittee for the House Judiciary Committee of the Maryland House of Delegates. It is Monday, February 24th at 4:08 p.m., and we are going to go ahead and get started. We have one bill on the agenda for this afternoon, which is House Bill 604, titled Vulnerable and Senior Adults Theft of Property by Caregiver, Family Member, or Household Member Prohibition. And so, colleagues, as you remember, we've heard this bill. This is a bill that was introduced on behalf of the Attorney General. And I do believe the Attorney General testified about the need for this bill. During their testimony, the Assistant Attorney General did testify that they had some amendments to this bill, which you should have a copy of those amendments in front of you. And so I don't know if maybe we should, I see Claire is here, council is here. Maybe Claire, if you could give us maybe a summary of the amendments, maybe we'll start there.
Sure. The amendments are actually taking the bill back to the way the Attorney General's office originally wanted it to be drafted. Long story, but due to a mix-up in the bill drafting department, it ended up getting drafted in the way that the bill was introduced. And so, after the attorney, and they can speak for themselves, but basically this is just taking it back to the way that they originally wanted it, which is just adding another element to our existing statute of exploitation of a vulnerable or senior adult. And this is just attempting to cover people who are family members or caregivers of the vulnerable or senior adult who may, misappropriate the person's assets, but they don't need to actually, trick them or fool them or strong arm them because they are in this fiduciary relationship. And so they just want to include this in with this crime to show that it is a fraudulent behavior.
All right, that sounds good. And then I don't know if we have in the waiting room any representatives from the Attorney General's office, but I think we were expecting maybe two individuals from the AG's office on the call today. Okay.
Do we have anybody? It would be good to just hear from them.
Yes, I see. Well, the Attorney General himself isn't here, but I do see Ms. Casper here as well as Ms. Clark here from the Attorney General's office. Good afternoon, Ms. Casper. Good afternoon, Ms. Clark. Thank you so much for being here. We were just reviewing the amendment that we have before us to the legislation. And so I believe Council summarized that pretty much the amendment reflects kind of the original intent of the Attorney General's office with regards to the bill and how there was a drafting error by bill drafting with regards to this. And so this, hope, from my understanding, reflects the actual intent of what you guys wanted to accomplish with this bill. So I don't know if yeah, so I guess maybe we need to start with the amendment because we'll have to adopt that first. If I can at least maybe just get a motion favorable for the amendment, and then we can go into discussion and questions for our guests here from the Attorney General's office. Oops, hopefully I didn't freeze. If I can just get a motion on the amendment.
You didn't freeze, Madam Chair. I,
Uh,
I'm, I'm, I know this may be premature. I know you want the motion. I don't know that I want to make a motion until I understand what's going on.
Okay, all right, that's fine. That's fine.
Agreed.
That's fair.
Thank you.
Okay.
Sure.
So I guess I don't know if folks have any questions then for the representatives from the AG's office. I know I have a few questions. But yes, Delegate Taylor.
Yeah, thank you, Madam Chair. My questions have to do with, well, the intent of the bill. You're adding caregiver and family member to an existing statute. It seems to me that already covered family members and caregiver because they would be considered a person under this statute. So I guess I'm trying to understand the why we are, singling out caregiver and family members. I mean, because we could single out a whole bunch of folks. You could single out, you know, um, other categories, a minister, their minister, their whatever. So to me, I just wanted to know why we were singling out caregiver and family member.
And Ms.
So
Clark.
it might be help for context for me to explain about a case that I just recently prosecuted. So the point is not to prosecute a larger net of people, but to prosecute a larger net of conduct. I had a geriatric nursing assistant who was working at an assisted living facility, and while she was working there, she stole the debit card of one of the residents who she was actually caring for out of the resident's nightstand while she was not there. She charged thousands of dollars worth of online purchases over a 2-week period. Because she did not use deception, intimidation, or undue influence to get the money, I was only able to charge her with theft, and I wasn't able to charge her with financial exploitation under this statute, which currently requires deception, intimidation, or undue influence. So what we're trying to do is any caregiver who steals in whatever form from someone that they're caring for, we want to be able to use this statute. And there's 2 real big reasons why we want that conduct to fall under this statute. Number one, because of the caregiver relationship, you're able to charge both the theft and the exploitation, and you're able to get additional and consecutive or concurrent sentences for it. And number 2, this statute, when we ask for exclusion from the from Health and Human Services for that person to not be able to be a caregiver anymore for any federal or state funded program, this statute is an automatic exclusion, and theft is not. As a matter of fact, the woman that I'm speaking of was already convicted of theft and still got the job anyway, and was still able to steal from the people that she was caring for. So what we're trying to do is make the stealing, in no matter what form, whether it's deception, intimidation, or undue influence, or simply just taking money without their permission and knowledge, which is really what the part that we want to add in here. And that's our purpose.
So, Ms. Cat, I'm sorry.
Yeah, I do have a follow-up to that, if you don't mind, Madam Chair.
Sure, Delegate Taylor, then we'll go to you, Delegate Phillips.
Yeah, I mean, full disclosure, I own a home care company, and we employ certified nursing assistants, geriatric nursing assistants who, become like family in these homes. And, we've had instances, that you've just described. But we've also had a lot of instances where the caregiver is so close to this individual, they, may use their card for purchases for the individual or but what happens is that the client might have dementia, forget that they gave consent, and then the other family members are like, oh no, you stole money. And they're like, no, I didn't do it intentionally. She gave it to me. So you get into this gray area. Just a little concerned here that, we are, in light of the fact that caregiving is one of those jobs where, you know, if you're good, you become very close to the family. And then we're short caregivers. So I don't want to do something that will actually scare away potential workforce either. So this is why I'm bringing this up. I'm not saying that we shouldn't do this. I'm just sharing some of my concerns about it.
Yeah, so we would still, obviously, we would still do an invest. This is just sort of a tool in our arsenal. I don't, you could argue that's a problem now, right? With the way the law exists, is that someone who does not forget that who forgets that they signed over and made someone their Social Security rep payee, that would be what we would prosecute as deception, intimidation, or undue influence. But that does happen, and that's why we always do a very thorough investigation. We would never charge someone on a whim. Our office does these investigations all of the time, and we actually specialize in. Our victims are all, vulnerable adults and people with intellectual disabilities and the elderly. So we always have a mind towards that. But what we'd also have to prove is that the person took it without permission and used the proceeds for themselves. So it wouldn't be a situation where they're using the proceeds for the person they're caring for.
Yeah. Okay. I get that. I just wonder how come why we can't use the current statute to do this, and why I'm still not clear on,
I
why.
guess the easiest way, Delegate, for me to explain it would be that we're trying to say that it shouldn't just be for deception, intimidation, undue influence. Actually, stealing from someone in your care is just as bad as those things and should be part of this statute. That's essentially why we'd like to add simple theft, whether it's cash out of their purse, whether it's a debit card out of their wallet.
Okay.
Okay. Delegate Phillips.
Okay. So my question, Ms. Casper, is couldn't we do this without stacking the penalties? Since we do have potentially two different charges, but we're talking about now potentially a consecutive sentence if you were able to get a conviction on both, but it's the same underlying charge. So could we accomplish the idea of once they've done it, they can no longer be a caregiver without having to stack the penalties?
Yeah, the stacking of the penalties is completely discretionary for the court. It's not even, we could ask for it under the current statute. It can be concurrent or consecutive.
But couldn't we write it in a way that it's just concurrent? If we had that. So we're not stacking. I don't want to even give the judge the option of doing that, to be honest with you.
Okay. Well, I guess it would have, because there is a section in the existing statute that they are separate offenses, that because of the caretaker relationship, that this is sort of a special, it's sort of an aggravator, if you will.
I understand.
And so presently that is deception, intimidation, or undue influence. If you charge that and the theft, you can get a concurrent or a consecutive sentence. I'm not sure how the statute would have to be redrafted for us to be, like I said, our goal is twofold: to be able to get an automatic HHS disqualification and to be able to have some flexibility. And especially with this woman that I was speaking of, she already has a theft on her record, and that did not deter this facility from hiring her. But if it was a financial crime, if it was financial exploitation of a vulnerable adult, that likely would have automatically excluded her, or been a sort of a red flag to any facility looking to hire her.
So, but this does not make it an automatic exclusion. I thought financial crimes were an automatic exclusion.
If we added this language in that we're proposing in the amendment, yes, it would make an automatic exclusion.
Okay, and we don't have. Maybe this is for Claire. Could the language be done so that we're not stacking the penalties, Claire?
It could.
I'm just sharing my preference.
I have a follow-up, I guess, to follow up to Delegate Phillips' question. If we remove the stacking, would it harm the eligibility for disqualification under HHS?
I don't believe so.
Okay. All right, that's fine. Delegate Schmidt, I think you had your hand up and then it just went away.
Yeah, can you maybe explain, Chair or proposer of the question, why removing the stacking? I mean, I'm not a defense attorney, yet we heard the explanation from Ms. Casper of why it's important, and now we're going back to where we started. So if I could get maybe some clarification there.
So the reason I raised that, question was for me, Delegate Schmidt?
Yes, sir.
Yeah, the reason I raised that is the idea of, you don't have to remove it. We could say, I believe, that it could only be concurrent. So they could be charged, and they could be charged with both. But instead of charging them and giving the judge the ability to say go from 10 years to 20 years, and colleagues would say, well, the judge wouldn't do that, but we're giving them the option of doing that. And that to me is, that's just more penalty, and I'm not comfortable with that.
So if you had 2 5-year penalties, they would be added together?
They
Or-
could be. If it's concurrent, then those 5-year penalties, they would run 5 years, and both of them would run together.
Together.
If it's consecutive, the judge could give a 5-year penalty and a second 5-year penalty, and they'd have 10 years.
Sure. Got it.
Any additional questions?
Thank you.
Oh, sure, no problem. Okay. I do have a question, and this came up during the hearing. I think Delegate Taylor was the one who asked this question during the bill hearing, but I wanted to bring it up again just to make sure and confirm with the amendments. I know Delegate Taylor, as she mentioned earlier, owns a home care business, and I think the question came up during the bill hearing about protections for the employer. I know that was a concern that was raised and something I heard subsequently, even after the bill hearing. And so Ms. Casper, Ms. Clark, if you could speak to whether or not this would impose any type of liability onto the employer or the company that the home healthcare aide may potentially work for, I think that would be also helpful.
I don't believe this bill speaks to any civil liability whatsoever. It is merely about criminal liability, so the person would have to have the intent to steal. It would not, unless the owner or the company somehow was complicit in the theft, knew about it, participated in it, got proceeds from it, it would not instill any criminal liability on them. I can't speak to civil liability.
Okay, Ms.
But this
Clark.
bill does not give them any civil liability.
No, it doesn't. I know, but there is a provision, I think, near the end where I guess this could also be I can't talk today, enforced under the I guess also under the commercial law article with regards to unfair and abusive and deceptive trade practices.
I can be honest. We have never used that section.
It's the language in the
It-
bill, so that's why I'm bringing it up, because I guess that would be more civil than criminal in nature, and
Yeah.
another enforcement tool that would be at the AG's disposal.
That is true. It's already in the existing statute. It's just not something that we've ever utilized. Typically, in a criminal case, we would always go against the defendant for restitution.
Mm-hmm. Okay. All right, but that's why I brought that up, just because
I
that
understand.
provision there in the bill. Okay. One of the other questions that I had was regards to, obviously this bill is really focusing on vulnerable adults, which I think and I am 100% agreeable that should be the focus and the goal of the bill. But the bill, I think, also pulls out language from another section in the criminal code where it is not only addressing vulnerable adults, but individuals who are of the age of 68. And I think I brought this up during the bill hearing just a letter that was submitted by the judiciary with a concern about just the age 68 part, and that the judiciary felt like just merely having a provision in the bill that a person who's at least 68 years of age would place the court in a position of determining, I'm just reading their letter, determining the mental and physical fitness of every witness solely based on their age and not whether any facts exist to warrant such a determination. And so, I know people who are 68 years old who honestly are probably in better shape than I am, are more spry than I am, who are just, nowhere near vulnerable as an adult. And so, I do have some concerns about just just having that age in there. And I understand that it was pulled from another portion in the criminal law article that talks about vulnerable adults and individuals at the age of 68. But one day, prayerfully, I will reach the age of 68. And so I do have a little bit of a concern about that.
Understood. I hope we all get to 68. So we've actually pulled it from this section
As
of the
do I.
code. We pulled it from this section of the code. If you look at the statute as amended, if you go into the section that's just prior to that, section 2, it already it talks about vulnerable adults in section B1, and then in B2, it says, and this is with regard to the deception, intimidation, and undue influence, the property of an individual that the person knows or reasonably knows is at least 68 years old with the intent to deprive. So it's actually already in this statute, and we really drafted it that way to be consistent. And that, we couldn't take that out because that's actually the existing law. We could take it out of our section that we're proposing, but it would still apply for 68-year-olds for deception, intimidation, and undue influence. But that we did that for consistency's sake.
Understood. Delegate Pastor, never mind. I thought you had a
Yes,
comment.
yeah, wait, I'm over 68, so I must be having a problem. Okay, here we are. I find that age in this particular bill disturbing because it does create, I find it biased. I understand from where you got that. And since we know that, as you just indicated, it will still flash back to the other bill or statute or law or whatever that mentions 68, then if that's the case, then I really don't see the reason for it, because if it's like one of the laws that I saw from Supreme Court dealing with juveniles, and there was an issue with the age. One person was 18, and then the next year something happened and the person was 19, and the court said, okay, there's no difference in the brain of the 68, 16, the 18 and the 19. So yeah, I have a problem with that 68. Maybe that's because I'm well over it and am quite certain that, and the people I know are, and that wouldn't be the case yet. There are those who are under 68. So are they excluded because they're not 68? So it's not a problem. So those are my thoughts about that age being included there. If it's going to refer back and for continuity, that's why it's there, then it doesn't need to be there because it'll go back to that one anyway. Thank you, Madam Chair.
Thank you, Delegate Pastor. Delegate Simpson.
Yeah, the judiciary, if you look, they're the only ones that had an unfavorable. And they said their only opposition was that it applied to any person who is at least 68 years, and said that this would place the court in a position of determining the mental and physical fitness of every witness solely based on their age and not the facts. So I don't know if they want to comment on that or are aware of that was the position of the the Maryland judiciary.
I don't know if you have anything additional to add, Ms. Casper.
I guess so. There is another bill that we sort of is a separate bill that we had added that language to. But I think with regard to this bill, the at some point the General Assembly decided that this 68 years old, was an appropriate age to say that someone was elderly because it applies to elderly people and vulnerable adults. We always have to prove that an adult is vulnerable if they are under 68, right? If they have some sort of intellectual disability or something. But I don't know what the reasoning was at the time this was done. And we are not really wedded to that. We just did it for consistency's sake.
Understood. Now my little history buff hat is kind of curious as to when that was enacted. And Claire, I don't know if you know the answer to that or if that's something we'll just have to try to research at a later date and come back to. I'm just out of sheer curiosity now.
I recall that it was about 8 years ago, 10 years ago, and I know the former chair, the age of time, so he was having a problem with it, and it was proposed to be and they increased it to 68, and I don't know exactly why, but that's just how the bill came in, and they did increase it a bit from how it was introduced.
To 68. Okay, at that time. Okay, all right. Legislative history sometimes is important, but okay. All right. Let's see. Are there any additional questions from anyone? Delegate Valentine, I don't know if you have anything, or I just want to make sure everyone's able to.
No, Madam Chair, I'm good.
Okay. Okay. Delegate Taylor.
Yeah, let me just ask this question just so I'm settled, because, after you go, Ms. Casper, I won't have you in the room to help us understand. Right now you have a case, right? And you don't have section 3.1 and 3.2 in statute. If we pass this bill, how is 3.1 and 3.2 gonna change? I'm still not understanding how it's gonna make a difference in the way the judge dealt with that particular case.
So it may not make a difference, right? Because it's ultimately up to the court whether to, with regard to the court, the judge, if I'd have been able to charge both statutes, both theft and this statute, the court would have the opportunity to give either a consecutive or a concurrent sentence. But it gives us more flexibility in what we can ask for. But what it really helps us do is, in addition to that, gives us more that other tool in our arsenal. It also, financial exploitation is a mandatory HHS exclusion, which means that person would not be able to be a caregiver for the next 5 years. A theft charge is not an automatic exclusion, and a theft charge the charge she was actually convicted of and pled guilty to in this case was just a simple theft over $1,500. So if questioned in the future, when she applies to be a caregiver again, she could go out the next day and apply, and somebody, the employer could say, well, we explain this theft. And she could say, I borrowed my neighbor's car and didn't return it. I shoplifted these items, and the employer wouldn't know the circumstances of that. With the financial exploitation by a caregiver, it would be noticed to any, not only is it the automatic exclusion, but it's a more specifically named crime, and it would get the attention of someone like yourself who was hiring someone to care for vulnerable adults.
And it's considered a felony, right? In
Yes.
this.
If it's over 1,500, it's a felony. If it's under 100, it is not.
Yeah, and I think that's consistent with other provisions in our code, other theft provisions in our code too, so. Okay, yeah, no, I think the automatic exclusion is important. Delegate Phillips.
That's what I was going to say. The automatic exclusion seems to me to be the most important element for me of this bill, and I will be more than happy to support it as long as we're not stacking. Just wanted to make that comment.
Okay, all right. Thank you, Delegate Phillips. Delegate Valentine.
Thank you, Madam Chair. That did generate one question for me.
Okay.
I too like the fact that they would be excluded from employment for a period of time. And just to confirm with Ms. Casper, that is only a 5-year. So if things change down the road, they would be able to have a second chance maybe down the road. Is that
Yes.
correct? Okay,
That's correct. It's only for 5 years.
thank you.
Okay, so it sounds like kind of where we are. We like the goals of the bill. We like the amendments for the most part. I think the two concerns we have, it sounds like it's the stacking and the 68 years of age is what I'm sensing right now from the committee. Okay. So I guess the question I have for Ms. Casper and oh, I think we might have lost Ms. Clark. If those are deal breakers for you, it sounds like maybe we might, and I guess I'm about to start to look at Claire, maybe for a second amendment to maybe address those things to add to the amendment before us. I think is kind of where we're at this point.
They are not deal breakers for us. Our main goal typically is to get the exclusion. We would like the ability to ask for more time, but understood. And as to the 68, again, we didn't just pick that number out of the air. That's
Understood.
why
Absolutely.
we're
Absolutely.
flexible with that as well.
Completely understand where you got that from. So okay. Claire, now I guess I have a procedural question. If the committee wanted to do an amendment to address those two things, would we need to have the amendment drafted and then come back and adopt that? Or could we adopt that kind of procedurally? I don't, just trying to kick the dust off a little bit and trying to remember how we've dealt with this in the past.
Well, it's really up to you. I could redraft the amendment. We could do it next week, or in view of the fact that time session, we could just do it in concept. We would take the 68 years old requirement out of language,
Right.
and then add a person who's convicted on this new B3 this new B3 may be separate from and concurrent with a sentence for any other crime based on the act or acts establishing the violation of this section.
Okay.
And don't say consecutive to, as the our standard language sometimes does. Just specify that a sentence for a person convicted under this new B3 has to be concurrent to any other crime based on the same conduct.
Okay. Delegate Phillips, I see your hand, and then Delegate Schmidt.
I just wanted to say, and thank you, Claire. I think the language that you just described is where I was going with the stacking. The other piece is, do we want this language to not be consistent with the other? Because we're not talking about taking the other out.
No.
So I get a little concerned about not being consistent. That's all.
Yeah, no, I totally understand that. I think what I was thinking about was just in the new language, removing that paragraph as it related to the 68-year-olds, but keeping the paragraph before with regards to the vulnerable adults. But I also understand the inconsistency with that. Delegate Schmidt, you had your hand up, then it went down.
Thank you, Chair. Yeah, once you acknowledge me, I took it down. You guys have me very, very confused here because we're talking about vulnerable adults and now we're removing language for 68. And now we're talking about removing some language as far as the judge. I mean, this is kind of what goes back to committee last week when we talked about not having a good defense attorney. It was, I don't understand. I mean, the purpose of the bill is protect the vulnerable adults from this theft and multiple other avenues, like it was explained. And I don't want to belabor the issue, but we're just removing all the teeth of the bill, it seems like.
Well, the vulnerable adult language would stay in there. So there's two.
How do we define that though? I mean,
Oh, it's defined under the code under, oh goodness, was it 3-601? I think it is, of the code defines vulnerable adult.
could that be a 21-year-old or does it have to
It
be?
could be a 21-year-old. It is
Okay.
based off of whether or not they have the capacity. And I don't have the full definition in front of me. Whether or not the adult has the capacity to make their own life choices and decisions. I'm kind of paraphrasing it, but that's the gist of it. So the definition of vulnerable adult that's currently in the criminal law article is not linked to age at all. It's linked to the individual's capacity. Is that, I see Ms.
So
Casper.
okay, that makes
In
sense.
your example, say age 18, but they're being taken advantage of by their caretaker. This bill would still continue to protect that individual.
Okay,
It
all
would
right.
still
Okay.
protect the individual who's 68, who is also a vulnerable adult because they are unable to care for themselves.
Got
And
it.
if a caretaker is engaging in abusive behavior, this bill would still protect them even if we remove the age 68.
Okay, that makes sense. Okay, good. All right, that
Okay.
you explained it different than way that I understood it earlier. So thank you.
No
So-
worries.
I have the definition of vulnerable adult. It's from 3604 in the criminal law article. It means an adult who lacks the physical or mental capacity to provide for the adult's daily needs.
Thank you, Claire.
Just what you said, Delegate Williams.
Okay, thank you. I have a whole bunch of hands. First, I think I saw Delegate Valentine, then Delegate Pastor, then Delegate Phillips.
Thank you, Madam Chair. Mine was not so much a question, but just a concurrence with Delegate Phillips about the consistency with the statute with the 68. That was my only comment.
Got it.
Liking to stay in the same consistent realm.
Okay. All right, and then Delegate Pastor.
And mine was the same thing, consistency. Ms. Casper said that the 68 would still be referenced because it goes back to something else. So there's no need to put it in this piece because that gives the implication that 68 is connected. That goes to a piece of Delegate Schmidt's question. Are we changing something? No, you can be 67. And if you're a vulnerable adult, you're a vulnerable adult. You don't have to be 68. But I'm sure I heard Ms. Casper say to what it referred and that it would still go back to that in any case. So I'm just talking about language as a language person. That is no need to be redundant in it, just like stacking or anything else. I agree with the stacking. But if we're going to change one thing, that is something that's not really a change because she has already stated it's already taken care of.
Okay.
And Delegate Williams did a very nice job of explaining it.
Thank you. Delegate Phillips.
So I'm my colleague in Baltimore County, I think the challenge is that 68 has to be in both places if we're going to be consistent. If we take it out, this is specific to the new charge. And so it has to go along with the new charge. If we don't have it, then the 68 will only apply to the theft. It will not apply to the economic crime. Is
that exactly what we're saying then? Then if you're 67, then we're not looking at the economic crime if the person is vulnerable? Is that what the bill is saying?
No, if the person is vulnerable, yes, But if
Okay.
the person is 67 and not vulnerable, then no.
And if the person is 68 and just did something that was stupid, but not as is very good at whatever he or she does, who could outthink you, outthink me, well, let's leave me out, outthink you or think anybody who's under 68, go to the gym, etc., not vulnerable, just it was a matter of the heart. It was a matter of something else. Then they still get to come under this because they are now deemed vulnerable. You know what? I'm not going to argue this point. Just do what you do, whatever you want to do, because I'm over 68 and I can continue to argue this point forever. All right. So clearly I'm not vulnerable. So whatever you're going to do, just go forth into the world with my blessings.
Okay. Claire, I think you wanted to make a point of clarification.
Yes, I quickly, in response to your previous question, I quickly tried to do some legislative history research about why this was originally put into the code. And I refreshed my recollection. That bill had been introduced on several years by frame district, including the large senior citizen home. And this was in the between 2005 and 2009, and it came in on several years. It's originally was 65 to add all people over the age of 65 to this vulnerable adult explanation. And I do remember that in the House debate over the age, and some people thought 65 was too young. It was amended up to 75, and then in 2000 changed to 68, and that's how it passed. So that's the story behind this age 68.
That makes sense. Okay. I thought I saw another hand and then I just lost. I don't know if it was you, Delegate Valentine. Nope. Okay. Okay. Well, I don't see any more hands at this moment. So now it sounds like we were going to keep the 68 for consistency's sake, but get rid of the stacking. Is that what I'm hearing? Okay. And
That's what I would move for, Madam Chair.
Okay, all right. And it sounds like we can adopt that in concept, even though we don't have the actual amendment in front of us. So if members feel comfortable adopting it in concept, I'm okay with that as well.
We can move the amendment as now, right? I'm good
Well,
with
I guess there's two amendments. There's the original amendment that was emailed earlier, and then I guess the conceptual amendment about removing the stacking penalties in the bill.
I think we can, I'm good with moving the First Amendment, and then the second one would just be coming out of subcommittee. We would just have an amendment out of subcommittee, right?
Yes, that would be correct.
So I'll move the previous.
Okay.
Second.
All right, it's been moved and seconded. All in favor of the amendment? I guess we just need to raise the hands. 1, 2, 3, 4. Okay. All right, it seems like the majority is in favor of the amendment, so the amendment passes. And then I guess, can I get a motion on the bill as amended?
I would the motion would be that the penalties for this, the penalties would be concurrent with other penalties based on the same statement of facts.
Okay. All right, along with the amended bill. Okay. And Claire, that's something that you'd be able to draft up for us?
Yes, I would combine it all.
Okay, all right, thanks. All right, so there's a motion. Is there a second?
Second.
Okay, thank you. All right, and let's see, I guess we got to do a roll call vote then on the bill as amended. Conway?
I'm sorry, can I hear
Oh,
it,
sure, go ahead,
please?
Delegate Pastor. I'm so sorry. Yes, we
I'd
probably
like
should
to
do a little
hear
discussion.
what the vote is on now, because it's going back and forth so many times, I don't even know. I'm over 68.
So the motion before us is on the amended bill with a second amendment to modify the penalties so that they are solely concurrent. If I got that right, Delegate Phillips.
Correct.
Okay. You're muted, Delegate Pasteur.
What is it saying? The
Oh gosh,
amendment.
Claire said it earlier and I don't want to repeat it because for fear of I'm gonna mess it up. But Claire, can you repeat the penalty language that you had proposed earlier with regards to the sentencing?
Yes, it would just be a clause that says a sentence imposed under subsection B3 of this section may be separate from and concurrent with a sentence for any crime based on the act or acts establishing the violation of this section.
Thank you.
I think everyone has that. Okay. Delegate Tolles, I see you have your hand up. Okay. All right.
Sorry, that was for the amendment.
Oh, okay. No worries.
Sorry.
Okay. All right. So there's been a motion and a second to adopt the bill as amended with both the original amendment that was emailed earlier as well as the second amendment from the committee. Any other discussion or questions? Okay. Seeing none, I'll go ahead and call the roll. Delegate Conway,
Yes.
Delegate Crutchfield,
Yes.
Delegate Ningola. Oh, I think we lost her. Okay. Delegate Pasteur,
He's on mute.
she is on
She may
mute.
not realize it.
Okay.
No, I realize, I'm sorry, I was doing something else, Delegate Phillips. Yes,
Okay. Delegate Phillips.
I can,
Yes.
Okay. Delegate Schmidt,
Yes.
Delegate Simpson,
Yes.
Delegate Taylor,
I'm a yes.
Delegate Tolles.
I vote yes. Sorry, I'm off camera. I'm driving to my next meeting. I hope that's okay.
Okay. All right. Delegate Tomlinson, I hadn't seen this afternoon. Okay.
Y'all did a lot of talking. I expect to be on the one
It's
bill.
okay.
The one bill this long.
Well, this is how it is sometimes.
This judiciary.
It's judiciary, exactly. Delegate Valentine.
I'm a yes.
Okay. All right, and I vote yes, and the measure passes. Favorable with amendments. Okay. All right, thank you so much, colleagues. This is the only bill we have before us today. We will probably come back again next week at 4 o'clock. I have a funny feeling we'll have more bills to work through. And so please, just listen out for your email and announcements. And I will see everyone tonight on the House floor.
Thank you.
Thank you.
Y'all
All
tonight.
righty,
Thank you, Madam Chair.
Thanks,
Goodbye.
everyone.
Thank you.
Bye-bye.
All righty, bye-bye.
I don't know what the reasoning was at the time this was done. And we are not really wedded to that.
Jameis Winston, that's my home. And Jalen Hurts. Come on for Jalen Hurts. Okay, so you gonna start him? I'm starting him. Who's gonna bench? You gonna bench Jameis Winston? I might gotta bench him.
So excited. This is, I mean, I've never done anything like this. So, of course, like a little bit terrified, but mostly just excited. It's awesome. It's a small film. It's 15 minutes, so it's very traditionally a short film, and it's about loss and loneliness, and the ways that we find reconciliation from that, and meetings with strangers, and so hopefully it's about finding a way out of loss and loneliness more than being staring in it. Yeah. I'm so excited. This
information about who he's brought on to lead the budget for the United States government. Byron Donalds, I have this clip here. I can't wait to show you of him realizing that he gave everything to Trump and for it to just slip away. And so let's just get right into it. So here is Russell Vought, who is going to lead the budget office for the United States government. It's Donald Trump's pick. He's also the author of Project 2025. And you might remember Donald Trump said that he had nothing to do with it. He knew nothing about it. He knew no one from it. That is turning out to be, as we all said, was going to be a lie. And here he is. Here's what he said in Project 2025. This is really interesting and I think instructive because this is the power he's about to have. So in the chapter that Vought wrote, he argued that the OMB director should present a fiscal goal to the president early in the budget development process to address the federal government's fiscal responsibility. He said, quote, though some mistakenly regard it as a mere paper-pushing exercise, the president's budget is in fact a powerful mechanism for setting and enforcing public policy. He has also said a few things here. This is what we can expect from him. He has claimed the presidents can unilaterally claw back spending without Congress. He has said, we are living in a post-constitutional time. What the hell does that mean? He has crafted plans for Trump to deploy the military to quash unrest and control the Department of Justice. And he has backed Schedule F to strip protections from much of the federal workforce. And what that last one means, it might be the most boring sounding, but it's actually the most important. So what that would mean is that there are all these federal employees that work. They work from the Bush administration, for Clinton, for Obama, for